What if I told you the brand new car sitting in your driveway right now, the one you're still making payments on, could legally force a billion-dollar car company to give you all your money back? Not a discount, not a coupon, not, "We're sorry, sir, here's a free oil change," your full purchase price. Every tax, every fee, every dollar of financing charges returned to you. By law, sound impossible? It's not. It's called the Lemon Law, and most people who actually qualify for it never even know it exists. Today, we're breaking down exactly how this law works, who it protects, what your car has to do to qualify, and why car manufacturers desperately hope you never watch this video. Let's get into it. First, where does the word lemon even come from? The term has been slang for a defective vehicle since the early 1900s, but it exploded into popular use in 1962, thanks to a now famous Volkswagen ad that joked about quality control using that exact word. In legal terms, a lemon isn't just a car with one small problem. It's a vehicle with a substantial defect, something that seriously impairs its use, its value, or its safety, and that defect keeps repeating itself, even after the manufacturer gets a fair shot at fixing it. Brakes that fail repeatedly, a transmission that keeps slipping, an engine that stalls out on the highway, not once, but again and again, even after multiple trips to the dealership. That's a lemon, and the law was built specifically to deal with cars like that. Here's something most people don't realize. There isn't just one lemon law in America. There are 51, one federal law, and 50 different state laws stacked on top of it. The federal version is called the Magnuson-Moss Warranty Act, passed in 1975. It protects citizens in every single U.S. state, no matter where you live. And here's the part that should genuinely surprise you. This federal law doesn't just cover cars. It covers any consumer product over $10 that comes with a written warranty. Toasters, washing machines, lawnmowers. If it's broken under warranty and the company won't fix it. This law has your back, but its most powerful use, by far, is with vehicles. On top of that federal floor, every single state, all 50 plus Washington, D.C., has its own additional lemon law layered on top. So depending on where you live, you might have even more protection than the federal baseline gives you. Now, here's where it gets specific. And this is the part you actually need to remember. Most state lemon laws use a similar formula to decide if your car legally qualifies. It usually comes down to two numbers: 3 to 4 repair attempts for the exact same problem, or 30 or more days where your car was sitting in the shop instead of in your driveway. And critically, this all has to happen within a specific window. Usually the first year of ownership, or before the car hits 12,000 miles, whichever comes first. Here's why that detail matters. A single repair doesn't make your car a lemon. If your check engine light comes on, you take it in, they fix it, and it never happens again. That's just a normal car. The law isn't designed for inconvenience. It's designed for chronic, unfixable failure. But if the same defect happens 3 or 4 times, if your transmission keeps failing and you keep dropping the car off, picking it back up still broken, that's when the law kicks in on your side. So let's say your car qualifies. What do you actually walk away with? There are 2 main outcomes, and most people don't know there's a difference. Option 1, a buyback. The manufacturer refunds you, and this is the part that shocks people. Your refund typically includes the total purchase price, plus your taxes, plus registration fees, plus your financing charges. Not just the sticker price, everything you paid to get into that car. There's one small catch. The manufacturer may subtract a reasonable usage fee, a small deduction for the miles you drove before the problem started. But that deduction is usually minor compared to what you get back. Option 2, a full replacement. Instead of cash, you get a brand new comparable vehicle. Same trim, same features, just one that isn't a lemon. And here's a detail that surprises almost everyone. In many successful claims, the manufacturer also has to pay your attorney's fees separately directly to your lawyer, which means fighting a lemon law claim often costs the consumer nothing out of pocket. Now, here's where things get complicated. and where a lot of people accidentally lose their rights without realizing it. Most state lemon laws are built specifically for new vehicle purchases. Buy a brand new car, truck, or SUV, you're generally covered. But used cars, that's murkier. Some states have separate used vehicle lemon laws with narrower protection. Others have almost none. Used car dealers are often legally allowed to sell a car as is, and 3 words on a contract can make a lot of your legal protection disappear. There is a federal safety net here, though. The FTC's used car rule requires every used car dealer to display a buyer's guide sticker, disclosing the exact warranty status before you buy. It doesn't create a lemon law remedy by itself, but it's the difference between buying blind and buying informed. The takeaway: buying new, you're generally protected. Buying used, read every word before you sign, because as is might mean no rights. There's a reason economists actually study this law. Back in 1970, economist George Akerlof published a famous paper called The Market for Lemons. His argument was simple. When sellers know more about a product's defects than buyers do, bad products can flood the market because buyers have no way to tell good from bad until it's too late. Lemon laws exist specifically to fix that imbalance. California and Connecticut were among the first states to pass them back in the early 1980s, and from there, it spread to all 50 states. So do you need a lawyer for this? Sometimes, but not always. If your case is straightforward, a clear defect, well-documented repair attempts, and the manufacturer is willing to offer a fair settlement, many people resolve their claims without ever hiring an attorney. But if the manufacturer is denying your claim or lowballing you with an unfair settlement, that's when a lemon law attorney becomes worth it. And remember, they typically work on contingency, paid by the manufacturer, not by you. So if you think your car might be a lemon, here's what to actually do. Document everything. Every repair visit, every date, every receipt. This paperwork is what turns "my car is annoying" into "my car is legally a lemon." Track your repair count. 3 to 4 attempts for the same issue, or 30+ days in the shop. That number might be the most important number in your life right now. And check your state-specific window. Most protections apply within the first year of ownership or 12,000 miles, whichever hits first. Miss that window, and your case gets significantly harder. Here's the bottom line. This law was never designed to protect car companies. It was designed to protect you. The person who saved up, signed the paperwork, and trusted the vehicle they bought actually worked. Most people who qualify for this protection never use it. Not because the law is weak, but because nobody ever told them it existed. Now you know if this saved you from a headache you didn't know you could legally fix. Share it with someone whose car keeps going back to the shop. They need to see this. Subscribe to World Law News for more legal rights you didn't know you had, because the law doesn't help you if you don't know it's there. We'll see you in the next one.